you have a story over at legalinsurrection.com that I don't understand. This was the headline. I know you're laughing at me because I didn't get it. I'm telling you, I didn't understand the thing. I should have gone to law school. Here's how it reads. I'll even throw on the glasses for you. Georgia federal judge rules racially discriminatory contracting is speech and expression protected by the First Amendment. Emergency appeal filed. You want to take it very slow and walk that through with me, please?
I'll take it very slowly, but it is ending up in a very bizarre situation. I'll give you the end result before I get to the beginning. And the end result is if this judge's ruling is held up, which is now supported by various civil rights groups, it could be the end of anti-discrimination statutes in the US. So the roles are reversed. The people who are supposedly for civil rights are arguing a position in a case which could end up destroying their entire regime of anti-discrimination laws. Stepping back to the beginning, Ed Blum is somebody who was behind the Harvard lawsuit on affirmative action, and his group there was Students for Fair Admissions. He formed another group, Americans for Equal Opportunity or something like that, and they sued an investment fund in Georgia because that investment fund had a special grant program which was only open to Black women. And the argument in that case in Northern District of Georgia is that that violates 42 USC 1981, which was a post-Civil War statute to protect contracting, essentially to give freed slaves the full right of contracting that white people had. And it basically says, I'm going to paraphrase because I don't have it in front of me, that everybody is entitled to equal contracting rights in the country.
And when we say contracting, we're talking about the ability to enter into contract, to have the opportunity to get a deal. And would that apply specifically to the federal government or state governments and not to private citizens?
No, that applies. There's no such limitation. So they did not bring that lawsuit under the Equal Protection Clause of the 14th Amendment, which was what the Harvard UNC cases were, because arguably this investment fund in Georgia would not be subject to those constitutional limitations as a private entity. I'm not sure why they didn't sue under any other anti-discrimination statutes. That was their decision, but they sued under this specific one. I think it was the Civil Rights Act of 1866. I think I have the year right. Maybe it was 1868. And that's what they sued under, a single count that this grant program, which discriminated on the basis of race, was unlawful under that statute because it deprived people other than Black women, which would include Asians, Hispanics, whites, arguably Black men, deprive them of their right to fair treatment and equal treatment in contracting. So that is the case. It was something of a rally around effect. Al Sharpton, Ben Crump, the usual suspects rallied around this investment fund. And the investment fund is run by Black women, okay? And they then created a grant program limited to Black women. And so they sued. And the judge ruled earlier this week that grant program was okay because by limiting the grant, which would be a contract, they'd have to enter into a contract with the grantee who would agree to abide by the grant terms, that by doing that, they were expressing a viewpoint that Black women have been excluded from the investment field. And this is a way of them expressing their viewpoint, was this grant program. And that is protected, the judge said, under the First Amendment as free speech and free expression.
So now it gets confusing because when I look at it, I say to myself, if I were to offer up, let's call it a scholarship, I'm Jewish. I know you are. If I were to offer up a scholarship to Jewish students, I can do that. I could say this is for Jewish students. How is that a problem regarding free speech?
Well, I'd have to look into that, whether you could in fact limit it, but that's not this case. The case in Georgia is race, and race is clearly covered by that statute. I don't know if religion would be covered. I'd have to look at it. But could you offer a scholarship only? Well, a scholarship, there would be a contract. Could you offer a contract solely to whites? I think Ben Crump and Al Sharpton would be the first to say, no, you can't. And they probably would cite the same provision that the plaintiff in the Georgia case has cited that says everybody needs to be treated equally with regard. You cannot discriminate on the basis of race with regard to contracting.
So now we ask ourselves, what did this judge say? Talking to William Jacobson, a Cornell law professor, legalinsurrection.com. What did this judge say in the case that has you particularly bothered about this ruling?
Well, what the judge said is that this discriminatory contracting was a way of expressing their viewpoint. But that's never been the case with anti-discrimination laws. And that's why this poses such a threat, that you can express a discriminatory viewpoint. You can do many things. You can hold it in your head, but you can't act upon it for anything that's covered by the statute. So it's never been the case that conduct would be deemed to be pure speech. And this is to be distinguished from like the Baker case and the website designer case in the Supreme Court, where the argument was that it was pure speech, it was pure expression, that was writing a message on a cake or writing a message on a website was not conduct, it was pure speech. And I think the court characterized it that way. And so that's not this case. This is a contract which the judge says maybe has some message attached to it, but it's still conduct. And if it is the case that discriminatory conduct, refusing to hire somebody, refusing to promote somebody, refusing to extend contracts to somebody, if that, as long as there's some viewpoint you have, is now lawful, that the First Amendment trumps all of this, that's going to be devastating to all the statutes that have been passed since the Civil Rights Act of 1866.
So your argument is that this win that people like Ben Crump are celebrating is actually the thing that will do in as radically problematic all the things they say that they're fighting for.
Sure. I mean, you could imagine somebody who says, well, we're going to make the bathrooms in our establishment only available to whites because we want to express the viewpoint that whites need better access to bathrooms. I mean, that's essentially what the judge, under the judge's analysis, that would not violate the Public Accommodations Law, would not violate the Civil Rights Act, would not violate the contracting rights. I mean, it would not violate anything because it's a viewpoint. And the Supreme Court has never gone there. The Supreme Court has never said that conduct, discriminatory conduct, is protected speech. The Supreme Court has said speech is protected speech. You can stand on the corner and say whatever you want to say, but you can't do the conduct. And the mere fact that the conduct may be to send a message, to send a viewpoint, is not enough. And the Supreme Court has always, as the plaintiff said in their brief to the 11th Circuit, because they're seeking an emergency appeal, the Supreme Court has been very careful never to go there. But this judge went there. And I don't think the judge, I don't know the judge. I wasn't at the argument, although I did read the transcript and I read the opinion. I don't think the judge maybe really wants this as the result. I don't think this is a judge who woke up that morning and say, how can I destroy all the anti-discrimination laws? I don't think that's likely the case, but that's the result of this. It creates an absurd result. And so what the plaintiffs have done, they, within 6 minutes, I think it was, filed an appeal. So the way this went down procedurally, there was a verbal ruling from the bench. There were all sorts of news reports that people were celebrating. Oh, the judge turned down, the challenge to the Black women's scholarship. Look, Ed Blum lost again. We're so happy he lost, because they're angry with him over the Harvard case. But there was no real reporting on what the basis for the judge's ruling is. So at Equal Protection Project, which equalprotect.org, which is our project that follows these things, we ordered the transcript. We contacted the court reporter because the transcripts are not generally available for 90 days unless you buy it from the court reporter. That's pretty standard at every court around the country. So we purchased it and I'm reading it. And then we got to the punchline where he said basically what I said. I said, wait a second, this is crazy. How can that be? Did they understand what this is going to mean? But we didn't write it up. This is only 2 days ago. We didn't write it up immediately because he said at the end, and I'm going to issue a formal written order and opinion. I said, let me wait to see. I mean, surely when he's writing this out, he's going to realize that what he said from the bench really doesn't make a lot of sense. And the written order and opinion is basically what he said from the bench. And as I've summarized here and paraphrased here, I haven't quoted him directly, but I've paraphrased him, that basically this Black woman only grant program, while it may be a contract and it may be subject to Section 1981, is still protected speech.
For anybody who wants to see this, head on over to legalinsurrection.com. There is the headline. Georgia federal judge rules racially discriminatory contracting is speech and expression protected by the First Amendment.